Thank you everyone for joining. We have with us today Seth Goodstein with ROI Law Firm. He actually rents office space in our Tacoma office. And so if you're ever in the office, you'll maybe see him around. He's in the Gig Harbor office as well. So anyways, I've used Seth now for coming up on 2 years, I want to say. He's been an attorney that I've referred, and I've used him personally for personal real estate matters. But Seth is specifically a real estate attorney. And Seth, I'll just give an introduction, but you can correct me if I say something wrong. But Seth is specifically, uniquely a real estate attorney. He doesn't do anything else, and so he really specializes in this. So if you ever have a client who needs help with a 1031 exchange, landlord-tenant laws, anything related to that, I highly recommend using Seth. He is very knowledgeable and very good at what he does. But today, we want to talk about landlord-tenant laws because recently, following throughout the COVID pandemic and now since then, there have been a lot of landlord-tenant laws that have been not favorable to the landlord. Let's put it that way. And the reason Seth thought of doing this meeting, and I agreed it was so important, is because as real estate brokers, we may think we understand landlord-tenant laws, but it is very important to not advise on something that you are not knowledgeable about. So Seth is going to talk for 5-10 minutes about some changes, and he's got some scary stories about some things that have happened recently where real estate brokers have really put themselves in a world of hurt, giving bad advice. And then he'll open it up for a question and answer. So go ahead, Seth, take the floor and correct me if I said anything incorrect.
Thanks. That was great. So I had, like Isaac said, a real life situation that raised a lot of alarm about the possibility of real estate agents advising on how to remove occupants from tenant occupied property to be sold. And this was actually kind of illustrated by a real estate agent that I know, not a Realty One agent though, who really overstepped the scope of what should be done and advised a client on how to get rid of occupants. The strategy she advised failed. The real estate agent is not an eviction lawyer. And as a result, the sellers had strategized with this agent they thought how to get rid of tenants starting in March with the idea that they would be receiving a vacant property and going to market now. But as a result of the bad tactics, the sellers are now going to have to do a 90-day notice that expires on September 30th. There could be an eviction process, and this would result in going to market probably in November, which is obviously a huge swing for the seller's expectations and what they might get out of the sale. So the point of today's visit is to implore everyone to have their seller landlords consult with an attorney and never as agents advise the seller, particularly in kind of a changing landscape, how to get rid of occupants. So I wanted to review a couple principles and then maybe go through the story a little bit more. So I guess you could say that possession is 9/10 of the law, and that's what we're talking about today. And Form 21 deals with possession, and so does the eviction law. And a quick review of Form 21, there's two things to be looking at on the first page. The first is that sellers have the option to deliver possession on closing or at some other time. The other one I wanted to point out is the choice of remedies, the seller's choice of remedies, where the parties can agree that the earnest money is the sole remedy for a breach of the contract. Obviously, a seller cannot deliver possession if a tenant won't leave, and the seller would therefore be in breach of the contract. And the remedies for such a breach might include a reduction in the sale price if the buyer goes through with the transaction and has to pay 2 mortgages or something like that, where they're trying to deal with navigating the landlord-tenant law. Or there could be some other damages, like maybe the seller has to retain the residence in which they live and wants or has to buy a storage unit or something like that. Point is, there's no limitation on buyer's remedies in Form 21. Those could be negotiated in Form 34, but they're not there by default. So by leaving it kind of loose when a tenant would leave, opens up the seller to some potential liability under the purchase and sale agreement.
Can I ask a question about that, Seth? Because it's along the same line. I don't want to get off topic. So just, I want to first off clarify what Seth is saying is, if you are listing a home with a tenant in there, and hypothetically the tenant is supposed to be out in 2 weeks or 3 weeks or 4 weeks, and you're like, oh, that's perfect. We're going to be pending in 1 week and then close 4 weeks after that. So we'll have plenty of time. That is still, it's not a sure thing, because the tenant could still stay there. And then what Seth is saying is, at that point now, and then again, correct me if I'm wrong, Seth, but at that point, now the seller is dealing with evicting a tenant who they thought was going to move out as told in 3 weeks. And now they're responsible because they were not able to close and deliver possession to the buyer. And the buyer can now essentially sue them for a handful of different damages that could occur. Is that a fair summary of what you're saying?
That is, or the buyer could, in theory, just walk away from the deal, and then the seller would have to, take whatever time is necessary to remove the occupant or find another buyer that doesn't care or something.
Which would be a better circumstance, honestly. I would be much more concerned. I mean, that's, life goes on if they have to find a new buyer in a few months after they evict the tenant. But like, the reason this is so scary is because the tenant can really throw a wrench in the situation. And now the seller is not just dealing with an eviction, they're also dealing with damages for a buyer if they choose to pursue that. So it's just really scary. What are some ways you can we put a clause in the form on a Form 34 that says something to subject to tenant rights or subject to tenant vacating?
Absolutely, yeah. Okay. I think you would say something like sellers making highest and best efforts to remove tenant. Describe what the efforts were, such as consulted with an attorney, sent, a notice to vacate, describe the notice. Sale is subject to tenant rights. The Form 34 would override the first page of Form 21 if it was written.
So that's super important. That's a great CYA, guys. So if you are ever listing a property with a tenant, you have to include a clause like that. And I'll work on, we'll hire Seth to write that properly so that you guys can then take that clause and kind of have a boilerplate template. However, there's very few things that are boilerplate about real estate because every situation is a little different. So if you are dealing with a situation like this, please come talk to me so I can make sure that I'm helping you through the process. Because again, if your seller gets sued, they could claim that you didn't advise them properly and they could sue you. And then ultimately that's suing us, right? So it's a big trickle effect. And so this is really important to me and this should be really important to you. And that's why we're having this meeting. Sorry, I'll stop talking now.
Okay, so yeah, I think that some review of just how to get rid of tenants generally is warranted to sort of explain why the alarm bells now. So in the recent past, before COVID, there was a series of 3, 10, and 20-day notices that would function to get rid of tenants in most of the state. Seattle was an exception. There's a couple other towns that enacted some higher bars, but generally you could get rid of people on a 20-day notice, your month-to-month tenants on a 20-day notice, and it was a 3-week eviction process. So if a landlord screwed up a notice, it wasn't that big of a deal. That could be sorted out and remedied in a few weeks or maybe even a couple months. So going back to my story, if the sellers thought that they were going to be selling now, under the old regime, they would correct their notice and they'd be selling probably in July or August, which is still the summer. So COVID occurred and increased the no cause termination notice to 60 days. Sorry, that was imprecise. It was the notice that you're going to sell the property and the tenants have to vacate. That actually is a cause. I said no cause, but that was incorrect. So that notice timeframe went to 60 days from 20. And there was certain requirements of the form, like it had to be notarized. But now the legislature has passed an emergency bill requiring a full 90 days of notice so that a tenant can vacate to sell the property. There's also assorted local rules. These seem to have proliferated during times of COVID. But those are depending on which city the property is located, and they do need to be looked into on a case-by-case basis. There's also specific ways to count the days, the notice time, and those depend on things like the due date for the rent and what the lease says. There's also specific ways that the notice has to be served. And this was all kind of fun and games when it was a 20-day notice, but screw up one of these things, and all of a sudden, a sale could be delayed by 5 months, and seasonality changes, and everyone's expectations change. And so that's why it's so important, I think now, with this 90-day notice, to have a defensible strategy to get rid of tenants in occupied property. So I guess I would go back to the story of my friend, the real estate agent, who did a little unauthorized practice of law. They apparently advised their sellers to send an email to the occupants that they needed to leave at the end of May, and that was their notice. The notice didn't contain the necessary information. Obviously, the email was not notarized. It wasn't served in accordance with the law, so there was just, a lot of problems there. And I guess that's okay if the tenant, feels they have a moral obligation to move out. But apparently, these tenants had some medical trouble and cannot move out. So now, again, they're going to have to do a 90-day notice specifying the end of September. And I think they're going to be lucky to get on the market in November based on all of that. Obviously, those sellers would be infuriated, and I don't know if there would be a claim against the agent, but by shortcutting that process and not involving an attorney, this agent really puts themselves in peril, and it really puts the attorney in a bad spot, because if I am referred these clients and the clients say, well, gee, why do I have to wait 5 months to sell my house? Then I have to tell them the truth, which is, well, your agent did something they shouldn't have, and you might have a claim against them because I have their interests in mind, a fiduciary duty. I have to tell them that. So basically, I have to rat out my friend, the real estate agent, and it puts everybody in a really bad spot. So I would suggest to have sellers referred to an attorney to mitigate the Form 21 provisions about possession and remedies, to create a valid and viable strategy to get rid of tenants. I can offer this consultation and notice for $500 or less. There's other attorneys in town that can do it too, but I would be able to help you out here. Isaac and I just sat and worked out a plan with a real estate client, and it honestly took over an hour. It took about an hour and 20 minutes to carefully review all of this person's circumstances and make a strategy. And finally, real estate asset is a serious asset. It should be taken seriously. So please always hire an attorney, especially with the new circumstances we've discussed today. And that would avoid putting everyone in a bad spot. So that's all I had to say for now, if there's questions.
Well, and let's use you as a bad example here, actually, because I think this is really important. So I just helped a client buy a duplex, and that client, was talking about, there was a lot of circumstances. He wanted, one side was vacant. He wanted to move into the side that wasn't vacant, but he wasn't sure if he wanted to do that. He said, maybe we'll move into the vacant side. And I said, and then he'll deliver 90-day notice. Anyways, there were all these things. And I was like, yeah, I think you can do that, but you got to talk to an attorney. And sure enough, I was wrong. I was completely wrong on the advice I gave him. To be fair, I did the right thing because I said, I think that's correct, but you need to talk to an attorney. That's what and so I did. I gave bad advice, but then I gave the correct advice where I said, that could be correct, but let's talk to an attorney. And that's really the key here, guys. Like, I have rental properties. I've been in the business for 6 years. And I was dead wrong on the information I was giving my buyer. Not 100%, but on a lot of little things. And those little things were very, very important. And it's impossible to keep up on all these different laws coming up, because as of May, what was it, Seth? May
It was May 22nd.
May 22nd, it all changed.
May 10th?
So the
Yeah.
information I was giving my client was correct before May 22nd, but I wasn't aware of the new changes. And so the point is, even if you think you have a really good head on your shoulders and you know what's going on, it's so easy to be have outdated information. And so again, it cost my client, well, actually, I don't know what it cost, but an hour and 20 minutes of Seth time. And we developed a full plan to get, to work with his situation. Let's just leave it at that. And so just so important. You just spent, in their case, they just spent over $500,000 on a duplex. Don't trip over a penny when it comes to consulting an attorney, because it really is a small cost if you can avoid an eviction down the road, or worse, a lawsuit. I mean, lawsuit is obviously the worst case. And if you, as a real estate agent, are giving the bad advice to the client, who then gives incorrect notice to the tenant, the landlord can get sued, and then he can sue you for his damages because you gave him bad advice. So the last thing I want to say on that is, if there are many circumstances in which I give advice and I say you should speak to an attorney though. If my clients don't take me up on my advice to speak to an attorney, I always put in writing, hey, just want to recap our conversation. I have encouraged you to get an attorney. You have decided to not get an attorney, which is your choice. But I've encouraged you to get an attorney. That was poorly said, but I say it in writing every single time, because if they ever come back and say, well, I had no idea, my real estate broker gave me bad advice, I can say, no, that's absolutely incorrect. Maybe I didn't tell him the right advice, but I told him I didn't know if I was correct and he should speak to an attorney. And so that's a really important lesson here too. And now we can open it up to any questions. Does anybody have any questions about this, or anything related to the new landlord tenant laws or anything like that?
Well, I'm not really up on them up here in Washington, but are they, is the federal moratorium still on for evictions, and how does that work, or if it is or isn't?
So the federal moratorium was controversial when it came out and was subjected to a lot of court challenges. And in the beginning it was upheld, but now a number of federal appellate circuits have ruled that it is either overstepping the authority that the CDC had to implement that, or they've ruled that it is simply unconstitutional. So it's definitely under attack. And in Washington State and the Ninth Circuit, Federal Circuit Court of Appeals, it hasn't been overruled. It's almost a moot point though, because Washington has its own eviction moratorium. All this stuff is supposed to be going away on June 30th. But it is of questionable application in Washington. There's currently a Washington State Supreme Court case that's examining whether it applies at all in this state. And then it expires by its own terms on June 30th, and then it's been ruled unconstitutional all over the country at this point, almost all over the country.
So are landlords able to evict at this point? If a tenant doesn't pay due to COVID or claiming COVID?
No. The three reasons under the state law to evict, or excuse me, the state moratorium is committing waste, nuisance, and illegal activity that substantially harms other people or property of others. The landlord wishes to move into the property, the landlord wishes to sell the property. That's for tenants who are on leases or were on leases. It's a bit of a different circumstance for like when people buy a house at a foreclosure sale or something and the people won't leave. That's kind of different. But just if you have someone that you let onto the property to pay rent, those are kind of the three ways to get rid of them. At least for the next, well, until the end of the month.
Ultimately, I think a good summary lesson today would be, we have, as licensed real estate brokers in the state of Washington, a limited license to fill in blanks on legal forms. We are not licensed to give advice beyond real estate sales. And there are some things within real estate sales that we should not be giving advice on. So ultimately, Similar to if you are with a buyer and they have an inspection and they say, hey, what do you think of this crack in the foundation? You you should not say, oh, it's no big deal, don't worry about it, right? You're not a licensed engineer. You don't know that it's not a big deal, right? You can direct them to resources that might confirm what you believe, and that may be that it's not a big deal, but we are not licensed to determine whether a crack in the foundation is a big deal. That may be a poor example, but it's the same thing here. We can, if somebody wants to sell their home and they have a tenant, we can say, yes, there are ways to get the tenant out. My understanding is currently you can give 90-day notice to a tenant if you are planning to sell a home. Beyond that, I don't really care to give more advice because I'm not an attorney. And so let me get you in touch with a real estate attorney who can walk you through that process. And it's a pretty small cost. Sorry to put you on the spot, Seth. How much is it for just an hour consultation? And it may be more than an hour, but how much is an hour consultation with you for somebody who is considering selling their home?
$300.
Got it. So $300 is a pretty small cost to pay when you're selling a home that's $400,000, $500,000. Your cost to sell is 8% or more. It's like, really? Are we gonna hesitate about spending $300 on an attorney? Like it seriously is so silly not to speak with an attorney. And then again, if they choose not to speak with an attorney, that's at their own risk, but cover your own butt by putting that in writing that you advise them to speak to an attorney.
Yeah, I guess I would also add that like my hour of time is different than other attorneys' hour of time because this is basically all that I do. So I don't need to go look things up or get back to you or, write a memorandum. I can answer things much more efficiently than someone that doesn't necessarily practice in this area.
Fantastic. And as always, if you don't want to pay for an attorney up front, you want to see if something is something you can handle without an attorney, you can always call me and I will either confirm, yeah, we need to talk to an attorney. That happens oftentimes, but there are some times that you may come to me and say, hey, do we need an attorney for this? And I'll say, no, there's ways around that. We can talk about it. Carefully, I would say that, but feel free to talk to me ahead of time and ask if it's a situation where you should hire an attorney. But when it comes to these type of things, again, I'm fairly experienced with tenants and rentals and so on, and even I completely butchered it with my client. And so that's just a perfect example of you just don't know it all. So don't be afraid to hire an attorney. In fact, be afraid not to hire an attorney. All right, well, does anybody else have any other questions? Thank you, Seth, for doing this. Really appreciate it. We'll include in the meeting notes and the recap email contact information for Seth on how you can reach him. And again, he's in our Tacoma office. So it's convenient to be able to schedule a meeting with him and just stop right in, use a conference room or meet him in his office. I highly recommend him. I've hired him myself with landlord-tenant issues and with creating LLCs for me and so on. Can highly recommend. So thank you, Seth.